5 seconds to go. Start. We have no doubt concluded that there is no evidence to establish the culpability of the appellant so as to find him guilty. Stop. But regarding the incident having occurred in the factory owned by the deceased accused number 1, there is certain evidence to show that the incident has in fact occurred. Stop. The evidence of PW7 and PW8 indicates that the laborers concerned were working in the factory. Stop. Unfortunately, accused number 1, father of the appellant is no more, to that extent the offence alleged against him has abated and therefore the finding recorded about his culpability cannot be examined. Stop. Though culpability of this appellant in the offence alleged has not been established and he cannot be held guilty in a criminal proceeding merely for being the son of the deceased accused number 1, there is however another dimension to this matter in this peculiar circumstance. Stop. Para. The allegation is that the laborers concerned were employed in the rice mill and the liability of fine under sections 16 and 17 of the Act must be attached to the estate, the rice mill. Stop. Notwithstanding the appellant not being culpable, he being the son of accused number 1, has succeeded to the business. Stop. Hence, he can be burdened with the financial liability even though the concept of vicarious liability does not arise in criminal prosecution and even if it be dehodes the requirement of section 357 of CRPC. Stop. Accused number 1, though not available at this juncture, had in the course of the trial taken the defense that there was no restraint on the workers, moving out to the market, etc., so as to contend that they were not bonded laborers. Stop. Therefore, what becomes evident according to deceased accused number 1 is that the said workers had worked in the factory but not as bonded laborers. Stop. However, neither has accused number 1 placed any material to show that the notified wages were paid, nor has he disproved the existence of the bonded debt of rupees 3000. Stop. Para. Further, the enactment under which the proceedings were initiated being a social welfare legislation and in view of the peculiar facts and to meet the ends of justice, we deem it appropriate not to interfere with the direction given to the appellant by the High Court to pay a compensation of rupees 50,000 to each of the workmen. Stop. This direction shall remain payable notwithstanding the acquittal of the appellant for the conviction under sections 16 and 17 of the Act. Stop. Para. For the reasons stated above, para, criminal appeals arising out of SLP criminal numbers 8683 to 8684 of 2019 are hereby allowed and the judgment and order of the High Court of Judicature at Madras in criminal appeal number 335 of 2013 dated 22nd August 2019 and 27th August 2019 are hereby set aside. Stop. The appellant is acquitted of all the charges, bail bonds if any stand discharged, we direct the appellant to pay an amount of rupees 50,000 to each of the workmen within a period of 3 months from today. Stop. Parties shall bear their own course. Stop.